And I'd like to introduce Janet Leeper. She is going to share with us some of her experiences, not only from being a new bencher, but also being a mentor to me in the practice of law. Thank you very much.
Good evening, everyone. Thank you for coming. I also have to thank Marlo Thomas for inspiring the topic of tonight's talk, and that's only for those of you who are baby boomers or older. For the rest of you, kind of rhymes with Barney, but I'm not going to sing. So I would like to really start with an idea, and this is an idea that's been forming in my mind for the years I've practiced, because in addition to being a fairly new bencher, for years I practiced in the discipline side, defending lawyers or acting for lawyers when they had complaints against them at the Law Society. So I've had the benefit of a lengthy relationship with the Law Society from a number of different standpoints, and now a slightly different one. But there is an ongoing idea at the heart of the relationship between the profession and you as individuals in the profession and the Law Society as a regulator that I'd like to challenge a little bit tonight and see what you think. We'll have some time for some questions, so I hope you challenge me if you have other points of view. But it all starts from a tension that has been identified by academics and writers, observers of legal matters and regulation, that we have this tension between one of the fundamental ideals of practicing law, which is our autonomy, our independence, and as a criminal bar, we really exemplify the values behind being independent. I mean, our job is to challenge institutions on behalf of vulnerable clients. Our job is to not always be so reverent about powerful institutions that can, in their drive to carry out sort of the public or collective will, can have adverse impacts on individuals. So we have those set of values that are really part of our core values as a bar. But then we have this larger professional mandate. By virtue of being a self-regulating profession, we have to also be responsive and accountable to the public at large and to some of those institutions. So here we have our day-to-day existence. We don't report to managers, we don't have supervisors, we don't live in cubicles. We have tremendous freedom, actually, in time and space in the way that we practice, and in a way that I think after a while you just start to take for granted until you actually start to go into other institutions or maybe take a different position or take a lateral move in your career. And for some, it can end up feeling like an irreconcilable set of values. In other words, the values are in conflict. But my thesis for the evening and the talk tonight is that this is really a false dichotomy, that in fact, each depends on the other to give it life. So really the yin and yang of an all-around complete professional. So if I was to retitle my talk, I would call it Embracing Accountability. And I would cite as evidence the notion that maybe we can look at the complaint function and the discipline function of the Law Society as really giving us, as lawyers, the benefit of a completely outsourced complaints department, with the cost shared among all of us in the profession who are regulated in Ontario. So you can see where I'm going with this, I hope. The Law Society can be thought of, yes, as a support to your practice, even when it's carrying out what some people dread, which is the complaint resolution function. So first of all, I think it's helpful not just to take this hypothesis and say, gee, that sounds great, because I can tell you don't think that yet. So maybe we will start with some numbers. Sometimes numbers help contextualize things. The Law Society receives around 5,000 complaints a year. Of those that come into the Law Society, 95% do not proceed to discipline, do not result in a finding against a lawyer of misconduct. So in any given year, although you may have a 1 in 10 chance of receiving a complaint, the chances of landing in discipline as a result of that complaint is extremely remote. It's sort of an important starting point. But if we go from this kind of context on the numbers, and we can recap it by saying, look, it's part of our professional responsibility. We know that theoretically. We may not like it when it happens to us personally, but theoretically, I think most people would accept it's part of our professional responsibility to maintain the privilege of self-governance. And if we add to it the fact that most complaints are resolved and can be resolved fairly easily, let's talk practical stuff then. How can you make the process as smooth as possible? I think the first thing, and this now comes from the fact that not only am I now practicing law, I also run really a small complaints department at the City of Toronto when people complain about councillors. So in the course of doing that, I've been able to meet some people whose job is to process complaints in rather large amounts. So it helps to understand from the point of view of the complaint receiver what that's like. The first thing is they have to review and consider every complaint. The fact is that some people will make complaints in a way that's a bit like the needle in the haystack. There might be a haystack of confusing, difficult to understand, perhaps not very appropriate language. But a regulator can't just say, well, you didn't type this up nice and neatly, or your fonts don't match, or you seem to be talking about things that are wholly irrelevant. If there's a kernel of a complaint in there, and it deals with a lawyer, and it's within the jurisdiction of the Law Society, yes, they have to kind of march through a number of steps, just as they would for somebody who puts together a tight brief and has it all, the I's dotted and the T's crossed. But some of them aren't even within their jurisdiction. You can imagine complaint receiving people often are a shop, they've had their door knocked on along with 5 other doors of other agencies that might receive complaints. Those ones will go elsewhere immediately. They'll be referred out. No jurisdiction, we can't help you with that. This is a matter between you and your lawyer, and fees, here's where you go to assess the account. And you won't hear about those. Some can be resolved by a telephone call to the lawyer or a letter. Some of them will look more like a formal investigation, but even those ones, investigation is no signal that this is marching down an inexorable path to discipline. It's merely, we need a response, we need your side of the story, we need some information, or we may need to meet and speak with you. But it's important to remember that in all of those scenarios, unless and until it gets to that discipline phase, which is kind of like in the criminal process, somebody's sworn in information and now it's in the formal track. Until then, it's being handled confidentially. You are required to respond, or you could face a finding of failing to respond. So the most important take-home message for new lawyers who are watching or here tonight, you must respond. It's worse for you if you don't, but it's unlikely to become a big problem when you do. And solicitor-client privilege is not a shield for your files. It's not a breach of privilege to respond to the Law Society. You're required by statute to respond. So you're best served by thinking of your communications in response to these complaints. The 3 Ps, keep it professional, make it prompt, and be prepared. Your goal is to get the file closed with your response, and if necessary, take appropriate action to respond to whatever is the substantive part of the complaint. Nadia Leva, my colleague, wrote an article a year ago called You've Got Mail in the CLA newsletter, and she makes the point beautifully. She writes, it's therefore critical that you do cooperate and provide information at the early stage of the complaint process. The quality of your cooperation will ripple through the entire investigation. And I love the word she chose because I just picture immediately this stone in the pond and the ripple effect. As lawyers, we know that sometimes the very tone of how we deal with an issue matters as much as the substance. So that if your first chance to show the regulator, the person who's received the complaint, that you are able to assist them, and you're going to do it professionally and you're going to give them all the detail they need, you've now moved 5 steps up the ladder pretty quickly. Instead of one at a time or grudgingly giving a piece of information and then they have to come back to you. And when I was acting for lawyers, I sometimes thought, you know, they've got this sort of scenario in mind where they see the regulator almost as sort of this sort of bad parent role, that they put every issue they ever had with their parents as teenagers onto the regulator, or they mistakenly sort of project sort of that anti-authoritarian feeling onto the person dealing with their file. But if you can look at it more the way the Hamilton Community Legal Clinic deals with complaints, they have a very plain language section of their website that says in big bold letters, if you are dissatisfied with our services, you have a right to complain. And they have a very clear policy. They describe for the people that they are serving if they feel they didn't get a good quality of service or if they weren't treated appropriately. They can complain, and here's how you do it. And that's really, any institution right now worth its salt is going to have a complaints policy. Why would we be different as a profession? We've had one for years. But I suppose because it's external to us, sometimes it's easy to kind of chafe against that, or the letter will come in at the absolute wrong time when you're busy doing 5 million other things and it feels like a stress. So how do you achieve the best quality that Nadia was talking about and an early resolution? Well, look at it this way. If it's a little trouble and it's only a little worry to you, you can probably fix it and respond. It's always good advice to pass your response by a trusted colleague or a mentor. But if it's bigger trouble, or even if it's a little trouble, and everyone's telling you it's little trouble, but it's a bigger worry for you, then I think it's even more advised to turn to a colleague or a mentor to offload either the emotional stress of it, or to find out if you really do have something to worry about and how to best manage it, or to hire somebody who does this kind of work. You might also decide whether your situation can benefit from some of the supports that exist via the Law Society, but not offered directly by them, and certainly not by the complaints people. So you may have heard of the Ontario Legal Assistance Program. It's funded by the Law Society, but it's managed independently, and it's a confidential referral to counseling if there are drug, alcohol issues, emotional issues, money issues, and they'll put you in touch with people who can help. Or you may be receiving a complaint because you're involved in something that's a much more complicated dynamic where you feel you're being harassed by somebody or discriminated against by somebody. And there's confidential sort of problem solving by Cynthia Peterson, who's the Discrimination and Harassment Counsel at the Law Society. So there are some things that run in parallel to situations that might bring a complaint across your desk that can help. It can be helpful to consider the nature of the complaints business, to think about how a matter-of-fact, cooperative, and positive attitude towards receiving a complaint can serve you well. The Law Society's core business is receiving complaints, and they receive them from all demographics. I went to a program that was put on by the New South Wales Ombudsman about a year ago, last fall, and as a joint project of all the ombudsmen who are complaint takers against government officials and officers, they created a manual on managing unreasonable complainant conduct, it's a wonderful manual because what it does is it allows you a window into people who are managing and handling thousands of complaints a year. And one of the things that they hear that you may not even be aware of, but it's part of their reality, is that often complainants also attack the complaint handlers. So that their complaint to you may be one of a number of complaints that will include how your complaint is being managed internally. And sometimes they will have complaints that change as soon as the original complaint is solved. They call that moving the goalposts. Other times they may make either reasonable or unreasonable claims of bias or corruption on the part of the person managing the complaints. And I think, for me at least, knowing that helps me understand how to respond to a complaint in a way that makes it even more likely that it will be a more, if not positive, at least not a negative experience. And it can be dealt with professionally and more like the professional you are when you deal with other people's problems. The book is wonderful, actually. It even helps because one of the things that might happen with us and can happen with us is that a complaint to the Law Society may start with a complaint to you. You may just not recognize it as a complaint, but it may be an issue or somebody says something that gives you a feeling that somebody's not happy. And if you can take on the role of being the complaint manager, you may as well be able to head off the issue before it becomes a more formal complaint and basically before the molehill becomes closer to being a mountain or something in between. So it's helpful to remember and consider strategies in dealing with complaints. I can tell you that this handbook, which includes even things like how to make a proper apology, believe it or not, there's a really good science behind how to craft a good apology. It's available online at the New South Wales Ombudsman's website. It's called Managing Unreasonable Complainant Conduct Practice Manual. And I commend it to you if you ever do come across a situation where you feel like you have to manage a complaint in a way that will allow it to be resolved before it becomes more formal or before it becomes to the regulator. One other sort of substantive area I wanted to mention before we have a discussion. When do you have a duty to complain? Sometimes you have to complain. And there have been some changes to the rule. When I first started practicing, it was essentially only if you knew someone had stolen trust money. There was no other situation where you had a positive duty as a lawyer to complain. But that's been amended. Rule 6.013 of our Rules of Conduct require lawyers to complain where they're aware of not only misappropriation of trust money, but where, if you became aware that somebody had just walked away from their law practice and abandoned it, obviously, if you're aware of that, you have to bring that to the regulator's attention so steps can be taken to prevent prejudice to clients. If you're aware of a lawyer involved in serious criminal activity in relation to their practice. If you're aware of a lawyer whose mental capacity has become so serious that clients are prejudiced, or indeed any situation where you become aware of serious client prejudice, there is a positive duty to report where you're expected to become the complainant. When are you expected to complain about yourself? Well, there is a situation where you are expected to advise the Law Society or complain about yourself if you like. If you are charged with a hybrid or indictable offense, either under the Criminal Code or the CDSA or under the Income Tax Act, or a dishonesty relating to the practice, you would refer to bylaw 8 sub 1 or perhaps consult with another colleague. But you may have, if you're facing charges yourself, a positive duty, again, to report. And these would be sort of on the regulator side. There may be corresponding duties relating to your insurer as well, which I'm not going to talk about tonight, but I'll just mention it for the sake of completeness. So, by way of summing up, in defending lawyers and advising them on complaints for over 20 years, I can tell you that I've never seen what I saw to be a miscarriage of justice in the way a complaint was handled if the lawyer responded appropriately and provided the information. The Law Society has a fairly stratified way of getting complaints before discipline. You don't see a lot of withdrawals because they get reviewed by a panel of benchers, and there are people that oversee the complaint resolution process, and they report to convocation regularly about how they're doing. Sometimes they've taken longer than people have wanted them to take to be resolved, but I have also found that if people follow up with the Law Society, again professionally, and remind them that this may be having an impact on someone's career or profession, and advise them there might be some urgency, that gets responded to. And as I said before, the tone can be as important as the content. Why unnecessarily irritate someone whose job it is to close your file and see that you actually did everything appropriately when you're responding to a complaint? And finally, to come back to where I started, the stakes are not nearly as high as people may initially perceive them to be when they get a letter from the Law Society. It's far more likely that it's all going to end without drama. So that's the bigger picture I wanted to talk about. My thesis is that it's part of what goes along with our independence and autonomy, and it needn't be a difficult process, and perhaps as the Ombudsman from New South Wales challenged us, because he was speaking to a group of complaint takers, perhaps you will come to relish grappling with difficult complaints. Thank you.
Thank you, Janet. I had requested if there were any questions, that if anyone would like to approach or email questions would be appreciated. In the interim, I do have a question. I don't know if you want to answer this or not. One of the greatest things that I hear from young counsel is we're terrified of the Law Society. And I know, and I heard loud and clear that there's a man, there's a mandate not only that we have to comply and cooperate when their letters are there or sent to you. I just, if you can reiterate why they don't have to fear the Law Society, why is it so important, because I've seen so many young counsel make a terrible error by not responding promptly, not obtaining counsel, not seeking out other lawyers more senior to them, just for simple advice. Can you just give us some good words of wisdom?
I'll do my best. I think the thing to remember is that the Law Society is staffed by people who take their professionalism seriously. And I don't know if you follow things like the 10 best employers, those competitions they have, but the Law Society has consistently been found to be one of the best employers. And to me, that speaks fairly highly for its functionality as an organization. And I can say that there's a high degree of professionalism on the part of the directors at the Law Society, and they in turn report to us, the benchers. We meet every month in committee, and then we meet in convocation. So there is this oversight of the regulator, which is an important piece. And everyone has to be overseen by somebody else. Everybody is. Anybody who takes complaints ultimately has someone they report to. And so I guess the first part of the question was, why be terrified of an organization whose reason for being is to allow you to continue to practice? And once you understand that that's part of what allows us to be independent, and if you think it's just a fairy story that maybe that could disappear, well, in 4 states in Australia, it did disappear. The government took over regulation of the lawyers because it was perceived that the complaints department of their law societies was nothing more than a drop box, a post office box, and nobody ever got anything done because the complaints weren't handled and the serious ones did not result in any sanction. Our law society isn't like that. Yes, you can see the sanctions, and now if people do face discipline, it's public, it's on the website and all the rest of it. All the more reason to handle it earlier. But believe me, and I've worked there with a lot of different people, I do not see a gotcha mentality in any way. They're carrying out a mandate that allows us to carry out ours. And of course, that's not going to mean that when you, or if you get a complaint letter next week, you're still not going to say, oh no, what is this? And feel your guts clench up for a second. Why not? It's human nature. It's like being pulled over for a speeding ticket. People get afraid of that too, even defense lawyers. But have the feeling and then come back to, okay, let's be rational about this. I know I didn't do anything wrong. People will complain, and my job is to respond. And if I don't feel up to it, or my personal life is difficult right now and this feels like just too big a cross to bear, guess what? You have people you can call. Just like what Paul was saying at the beginning, you can call people to ask them legal questions. Well, these questions are fair game too. You can call your friends, call your mentors, call people older than you, call people and ask them who you should call. And believe me, people will take those calls because we all understand. I mean, that's part of we're in this together. We all understand what that feels like. And people will help you get through it and give you good advice. And we'll read your letters and say, you know what, this word makes you sound defensive, just take it out. Or this sounds like a rant, not necessary to answer the complaint. So that would be what I would say.
I attended the Women in Litigation Conference hosted by the Law Society. And at the conference, a topic that was talked about quite a lot was the idea of the imposter syndrome. And I know that I've been guilty of it, and I know that some of my female colleagues have been guilty of it, and maybe some men have been guilty of it too, but it seems a lot less apparent with my male colleagues. What the imposter syndrome is a phenomenon where people are unable to internalize their accomplishments. And despite external evidence of their accomplishments, they find it impossible to believe in themselves or to attribute those accomplishments to any doing of their own. And even proof of success is dismissed by people suffering from this syndrome as due to luck or timing. You know, that was a great witness, or I had a good set of facts. And it also involves a lot of worrying and self-criticism. And apparently the imposter syndrome is primarily suffered by women. And it's prevalent in women who practice law, especially those who are in litigation. When I come out of a trial, even if I've won the trial, I find it hard to give myself any of the credit. I'll give anyone and everyone credit except for myself. So again, it's always because I had a good witness, or I had a good set of facts, or the judge could see the merits of my case in spite of myself. And I just wanted to put that out there because I think it's something that a lot of junior female counsel are suffering from. So that's the first thing I wanted to mention in talking about the issue of women in the law. Having said that, though, I want to stress that this imposter syndrome is not something that makes us weak. It just means that we're very self-critical and that we hold ourselves to almost an impossible standard. So even though I'm not excited about the one who has to be the one who has to sit up here tonight and give this talk, I'm glad that we are talking about it and that it's something that we're discussing as a community. And we're here tonight to talk about women in the law and why it's different for us than it is for men. And what unique struggles do women face that men are not facing in this business. And we're also here to discuss equality in the workplace, and that's not something that we should be striving for just between men and women. It's also something that we should be striving for in evening the playing field between women in different areas of criminal practice, in the same field, because there is a lack of equality between certain benefits that Crown Counsel get and then benefits that defense lawyers, for example, do not get. Female lawyers face certain difficulties in the workplace that men don't, and it's clear that as a whole, women are concerned about ensuring that they have time for pursuits and responsibilities outside of the workplace. And this preference has led women to pursue specific career paths that tend to preclude private practice. Whether this preference is a result of free choice or the result of systematic forces is a matter of some debate. And it's not to say that women haven't made their mark in the legal community. In criminal law alone, we have a group of very talented female counsel and judges to boast of, and we've got some very talented women here tonight: Justice Michelle First, Janet Leeper. We've had Justice Kelly Wright speak at this event as well. Nadia Leva, Francesca Yesko, and Marlis Edward, just to name a few. In fact, the number of women in law has changed dramatically over the past 30 years. And in 1986, women made up 20% of law practitioners. In 1996, they made up 30%. And in 2006, women made up almost 40% of law practitioners. In recent years, women have consistently made up more than 50% of the new calls to the bar in Ontario. And the average age of a woman called to the bar in Ontario is 30 years old, which of course means that women lawyers are facing their career tracks and their parental tracks all at the same time. And this is the key, is that women are more likely than men to work in government or in institutional settings, rather than in private practice. So 21% of women lawyers work in government versus only 11% of men. When I started in criminal practice about 3 years ago, I noticed a lot of women around. I knew a lot of other female articling students. I saw a lot of women in the Crown's office. I saw a lot of women on the bench. And even the Chief Justice of the Supreme Court of Canada was a woman. So women do have a large presence in criminal law, but I think the detailed picture is not as promising as what the numbers would suggest. And one day I was in the cafeteria at the Newmarket Courthouse, and I was speaking to a particular judge, and we spoke on the topic of women in the law, and the judge remarked on what he saw as a significant gap between junior women counsel practicing criminal defense and those practicing with 10 or more years experience. And when I started looking around and I started asking my fellow female defense counsel about this gap theory, they not only confirmed it, but they also provided me with a reason why. And I heard the same story over and over again, that women are facing struggles in law that men are not. What's clear is that women bring a very unique set of values to legal work. And women lawyers are just as committed to their profession as men, but women experience greater pressure and more responsibilities to manage outside the workplace. On top of that, it seems that a large percentage of us may also be suffering from the imposter syndrome. And as we all know, the practice of law often makes very excessive demands on your time and on your energy, and it makes it difficult to achieve a healthy work-life balance and to handle obligations of childcare on top of that. And flexible work hours are hard to find, especially in sole or small firms, and there are fewer supports in sole or small firms than there are in larger firms. And of course, any difficulties that women face in that regard are magnified if the woman is a single parent. So keeping women in criminal defense and in private practice should be something that we're all concerned about, because women bring diversity to the workplace, and increasing diversity in the legal profession benefits everybody. And of course, the more diverse the workplace, the more ideas that are brought to the table. And men also need to be engaged in the process. We need men to listen to the women that they work with, and to think inclusively about family responsibility, and be educated about the impact of family structure on women's abilities to participate in what's very often the hectic world of criminal law. And as society's values are changing, men are increasingly taking on family responsibilities and looking for flexibility as well. At the Women in Litigation conference last week, Marie Heynen was asked how she did it, how she successfully balanced family and career. And her response was, well, how did my husband do it? And I thought that was brilliant because, and I think she's right, equality means that that question is not only posed to women, but it's posed to men just as much. What's certain is that women are not going to succeed unless this is not a women's issue anymore. And women are at the forefront and are leaders on this topic, but men have to be on board too. And since our profession is one based on our shared values of civility and integrity and respect for our colleagues and for the court, it should not be a problem for anybody in this room. We've come a long way since the days when Marlis Edward began her practice 30 years ago. And at the CLA Fall Conference last year, Marlis gave the advocacy lecture in memory of Justice Sapinka. Marlis' speech was inspirational, and she reminded us all of how important our role as participants in the justice system is. She remarked on how much things had changed for women over the last 30 years when, you know, they didn't have robing rooms in the courthouses, so she would have to change in the broom closet. And I agree with her that things have changed a lot, but my female colleagues and I seem to have consensus that some men still engage in subtle and not so subtle undermining of women in the legal community. I can't tell you how many times I've seen men mystified at my status as a lawyer. And you know, the question's been posed to me in every possible way. You're not a lawyer, are you? You're a lawyer? My favorite is, are you Paul's assistant? And if anyone has noticed the improvement in Paul's work over the last 3 years, you know I'm not just Paul's assistant. And I don't intend on painting all men in this field with the same brush. There are some wonderful male counsel out there who are willing to help you and mentor you and who don't see gender as an issue in this field. And I think all young counsel, whether you're male or female, you need a good mentor. And you need a mentor who puts your education at the top of the list. And I've been very lucky in that regard. But for female counsel, even if you have a great male mentor in your life, I think it's also important for you to have a strong female mentor. And you need someone to guide you through the particular struggles that you will face as a woman in this field. And that's why we started the Garage series, was to be leaders in helping educate junior counsel and encouraging other lawyers to participate in the same way. I just want to talk a little bit about certain solutions that have been put in place for women in private practice to kind of prevent what seems to be a mass exodus from private practice. The issue's garnered a lot of attention and a lot of support in the last decade. The Law Society has launched some very promising initiatives targeting this issue directly. And the initiatives are designed to empower women to take charge of their careers and to help them maintain the viability of their small practices. 80% of firms in Ontario are of 5 and fewer lawyers. And the Law Society has implemented specific recommendations and resources for sole and small firms. In March of 2009, the Law Society launched its Parental Leave Assistance Program to assist lawyers in small firms and sole practices. The program aims to help cover expenses associated with maintaining a practice during the lawyer's parental or adoption leave by providing up to 12 weeks benefits. And to qualify, male or female lawyers must be in a firm of 5 or fewer lawyers and have no access to other benefits. To date, over 60 applications have been approved, and not surprisingly, men are also taking advantage of the program. About 27% of applications for the Parental Leave Assistance Program have been by men. In April of 2009, the Law Society also launched the Justicia Project, which aims to create a group of medium to large firms committed to identifying and adopting principles and best practices aimed at keeping women in private practice. Currently, there are 56 firms who have joined the project and who have made a commitment to track gender demographics, to review their firm policies, and to develop programs aimed at keeping women in private practice. The Law Society has also launched new online resources specifically for women called the Women's Online Resource Center. And it offers online practical supports for a variety of topics, including mentorship and managing work-life balance. And these initiatives by the Law Society, taken together, I think, paint a picture of the priorities that women are bringing into this field. There are, the Law Society has also launched the Lawyers Contact Registry, and the purpose of the registry is to help lawyers maintain their practice during a leave of absence. So whether it's a maternity leave, or you're busy on a complicated trial, you can go on to the Law Society website and hook yourself up with a lawyer who will come in and take over certain aspects of your practice while you're unable to be there. And we can't forget that law firms have a legal and a professional duty not to discriminate. Law firms are required to provide equity in the workplace, and office policies and procedures have to reflect the human rights legislation and the rules of professional conduct. The Human Rights Code of Ontario prohibits discrimination in the workplace, and Rule 5.04 of the Rules of Professional Conduct provide that the law firms have a legal and professional, law firms are not to discriminate based on, amongst other things, sex, sexual orientation, age, marital status, and family status. Discrimination in the practice of law breaches acceptable standards of professional conduct, as well as provincial human rights laws. The Law Society has released a guide to developing policy and workplace equity in law firms. So if you or your law firm, no matter how big or small you are, want to implement a workplace equity policy, you can go on to the Law Society website, and they have guidelines there that you can adapt to your own use. So with all these resources that I've just spoken about put in place, things are starting to really look up for women defense counsel in private practice. But I don't think it's where it should be quite yet. For one thing, I think there needs to be a formalized mentorship program for women. And as much as senior counsel are great about inviting you to call them up whenever you need anything or you have any questions to answer, sometimes we just don't feel comfortable doing that. So it would be, I think, beneficial to junior female counsel to have somebody that they can call up, a female senior counsel, to discuss the particular issues that they're having, whether it be imposter syndrome issues, whatever it might be. I think that's something that needs to be put in place. So just in conclusion, I just want to say that, the initiatives that have been starting are very promising. But the fact remains that women in private practice, when they want to have a family, they have a very difficult decision to face. And I don't think it's a decision that they should have to make. And as much as things have changed, the resounding message from the women that I've spoken to is that we should still all be examining the gender dynamic in law. And female counsel in private practice deserve what females who leave private practice, that 21% of females who leave private practice to go work in government institutions. We deserve the same kind of support and the same kinds of benefits as women who leave private practice. As young criminal lawyers, we have the opportunity to learn from some great defense counsel who are, very helpful. And at events like this one, and CLA conferences, and the Advocate Society conferences, and anything put on by your provincial or your local bar associations. What we keep hearing is that to practice criminal law, you have to have passion. You have to have passion, and you have to be dedicated in order to succeed. And my point is that it seems for women that something a little more might be required in order to succeed in this practice. So we want to cultivate a new generation of lawyers who are just as skilled, just as dedicated as their predecessors. We have to support them in their journey. As Marlis Edward reminded us all, our role as defense lawyers is an important one, and it's central to the protection of the rule of law. But the culture of law will have to undergo a fundamental shift to one that's more family-friendly if women are expected to stay in private practice. I think it's a great sign for the future that we're all here talking about this tonight. So I want to thank you all very much for coming and listening. Thank you.
And it's not often that you're able to hear from two jurists, and two jurists who are speaking together, as they did back in days in August, on topic of criminal law, except if you go to the Federation of Law Societies conferences, which are also fantastic. In any event, Justice first. Justice Watt, thank you.
Thank you. So we're going to go a little bit out of order because we want to try to deal with the cases we think may be of most interest and value to you first, rather than some of the ones we've put on the list because we think they're interesting cases, but you may find them a little bit more esoteric. So we're going to start with the topic of searches of computers. And since David likes to say that his computer is always with him, and for those of you who are following on webcast, he's holding up his pen because he doesn't know how to turn on a computer, I will deal with this topic, and then we'll flip over to something he wants to talk about. So there are two cases in this category. They're both decisions of the Ontario Court of Appeal from this year, one of them a very recent decision. The first of the two is the Regina and Cole case. And in that case, the accused was a teacher who had a laptop that had been issued to him by the school board, but continued to be owned by the school board. A computer technician found by looking at the school's server that the accused had some nude photographs of a student on his meaning the computer he was using, its hard drive. The technician went to the principal, who told the technician to copy the photos onto a disk, and also required the accused to hand back the laptop computer. The laptop and the disk in turn were turned over to the police by school officials, and of course the police did what they seem to like to do with computers quite often, which is to search the computer and the disk without a warrant. The Court of Appeal held that the police search of the laptop violated Section 8 of the Charter. Why? The court said the accused had a reasonable expectation of privacy in the contents of the laptop, because even though it was owned by the school board and continued to be owned by the school board, the accused user had the exclusive use of it. He was permitted to make personal use of it on the facts in the case, and he had protected access to it by use of a password. On the topic of the disk, on the other hand, the Court of Appeal concluded that there was no Section 8 violation because the data that ended up on the disk looked at by the police had been found in plain view on the school's server. On the topic of Section 24(2), dealing with the search of the laptop, the court emphasized that the search of a personal computer is among the most invasive of searches, and so excluded the evidence. Why do we think this case is important? Well, as you know, up until very recently, there's been almost no appellate authority on the topic of searches of workplace computers. The topic has arisen on several occasions at the trial court level, and I can tell you that these are difficult decisions when you're trying to apply traditional search principles in non-traditional areas like searches of computer and computer data. You know, many people in their workplaces use computers that have been provided by their employers, not just for work use, but for personal use from time to time as well. And it seems to me that workplace computers are going to be a real potential goldmine of information for the police. So it's good to see the Court of Appeal starting to develop some search parameters for us in this area. I think we're going to see more employers developing written policies that govern the extent to which an employee may use a computer for personal purposes, and the extent to which, therefore, an employee could ever say, I have a reasonable expectation of privacy in a computer that my employer owns and maintains for me. The next case is the more recent of the two, and that's the Jones decision, which you probably have seen, if you haven't read it yet, referred to in the media. It got quite a bit of media play not too long ago, and in that case, the police investigation was a fraud investigation. They got a search warrant, and under that warrant were permitted to seize and to search the accused computer. While looking at the contents of the computer, the police found evidence of child pornography. They then continued, after getting advice from a senior Crown Counsel, to examine the computer, not in terms of the fraud investigation, but now for child pornography. Looking very actively and aggressively for that kind of evidence, they looked in some video files on the computer hard drive that they admittedly would never have looked at had they simply been looking for evidence of fraud, and of course found a great number of images of child pornography. The Court of Appeal held that the search of the video files violated Section 8 of the Charter. Why? The initial warrant had authorized a search of the computer and its data for evidence of fraud, but not for evidence of child pornography. So the Court of Appeal, with Justice Blair writing the decision, said that once the police discovered that initial smaller amount of child pornography, they should have gone back to a justice of the peace. They should have got a second warrant directed to a search for evidence of child pornography. And in particular, the court said, because the Crown tried to justify the search of the video files using the plain view doctrine, Justice Blair and his colleagues specifically said those video files that the police looked in were not in plain view. However, when the court turned to Section 24(2), they determined that the evidence should not have been excluded. The judge at trial had excluded it. The court said that was wrong. And the reason they said it was wrong was because the police had taken the step of going to a senior Crown Counsel and getting some advice on the issue of whether or not they could continue to look for evidence not of fraud but of child pornography. The Crown Attorney gave what was considered to be reasonable advice given the state of the jurisprudence at the time. So even though that advice turned out to be incorrect in hindsight, the court was prepared to say that the police had acted in good faith, and so under Section 24(2) there should not be exclusion. So why do I think this case is important? Well, again, continuing on the theme of searches of computers, there's a very, very good discussion in this decision about the nature of a computer and how and why a search of its contents, of its data, is different than a traditional search, and to some extent there are some tips in the judgment as to how a search of a computer should be approached. So if you've got a computer search case, look at this decision. It may give you some ammunition to work with in court. David, do you want to deal with the topic of Crown repudiations of plea agreements?
First of all, let me suggest to you that although many of you are at a relatively early stage, some of you at a very early stage of your practice of criminal law, do not be intimidated by the prospects of appearing before our court, the Court of Appeal for this province. It is an excellent experience for you. Don't believe all of the nasty things you read about us in the news media. They're not all true. But I was fortunate enough when I began practice to practice in what's now the Crown Law Office Criminal. It was then, and more appropriately, I think, called the Criminal Appeals and Special Prosecutions Branch. So I had the opportunity in the first week that I was in practice to appear on a motion for leave to appeal to the Supreme Court of Canada, which was the first court I appeared in. It's been all downhill since then. And those motions were argued live at that stage, not on paper as they are now. And the second court before whom I appeared, or before which I appeared, is the court of which I am now a member. So if you have the opportunity to do appellate work, please do not shy away from taking that opportunity simply because you are at an early stage of your practicing career. If you have the chance, take it. Speak to some of more experienced counsel. There are many of them around who appear there on a regular basis. Take their advice, and please come and visit us. We don't we can't guarantee a success, but we'll try our best to give you a fair and considered hearing and decision. The reason why I suggested that the case of Nixon is important is because, as you all know, there are a great many cases in our administration of criminal justice that are resolved by way of agreed upon pleas of guilty. And often they are accompanied by joint submissions on the issue of sentence. Not always, obviously, but in many instances they have. So Ms. Nixon found herself charged with a series of quite serious driving offenses. A couple of counts of dangerous driving causing death, a count of dangerous driving causing bodily harm, and parallel counts of impaired operation. And what happened at the trial stage was that she entered into a plea agreement with the prosecutor. And this case comes from Alberta, and I didn't think they made agreements like this in Alberta. But this was the agreement. She was to plead guilty to careless driving under their equivalent of our Highway Traffic Act, the Traffic Safety Act. She would pay a fine of $1,800, and the prosecutor would withdraw all of the criminal code offenses. Now, this is a case in which 2 people get killed and somebody gets seriously injured. Now, because of the circumstances of the offenses, the prosecutor prepared a report for senior ministry people. The acting assistant deputy minister looked at it and said, "What?" Concluded that the prosecutor didn't really properly assess the strength of the prosecution's case, and said to the prosecutor, "Look, Ace, you're going to have to withdraw this resolution agreement, and you're going to proceed to trial on the counts of dangerous driving." So defense counsel, somewhat chagrined by the disappearance of this excellent deal, brought an application under Section 7 of the Charter alleging abuse of process and sought a direction that required the prosecutor to complete the bargain. The application judge granted the order, said to the Crown, "You have to proceed in accordance with the agreement." Another judge took the plea, acquitted of the criminal code charges, took the plea on the highway safety legislation. Guess what? The prosecutor appealed. The Alberta Court of Appeal said bye-bye to those acquittals and ordered a new trial. The accused then appeals to the Supreme Court of Canada, unanimously dismissed the appeal. Why is it important? Because the court said that the decision taken by, and I'll use the term, the prosecution, to resile from or renege from the original agreement was an act of prosecutorial discretion that was reviewable, but only reviewable on the basis of an abusive process. And as you, I'm sure, are aware, there are really 2 categories of abusive process. The first, prosecutorial conduct that affects the fairness of the trial, And secondly, prosecutorial conduct that contravenes fundamental notions of justice and thereby undermines the integrity of the judicial process. And the court unanimously held that a repudiation of a plea agreement could constitute an abuse of process on either one of those two bases, although it seems to me one is a little more obvious than the other. Plea agreements, the court said, rejecting a decision of Justice Hill in the Superior Court, are not contractual undertakings, but the circumstances in which the prosecution can resile or renege from those are and must remain, and this is of importance to you, rare. To determine whether the decision to repudiate amounts to an abuse of process requires the judge, on your motion, to examine all of the circumstances. And because acts of prosecutorial discretion are generally beyond the court's reach, because they're not made in the presence of the court, there is a threshold burden on the accused. But that threshold burden, you say, hey, well, just wait a minute here. Why should the accused have imposed upon him or her a threshold burden? Well, the imposition of a threshold burden, you'll see, is not particularly onerous because it's met by proof of a plea agreement and proof that the prosecutor has reneged from it. And if that is established, as it should be comparatively easy to do, then the evidentiary burden shifts, as it should, to the prosecutor, who's obliged to adduce evidence of the circumstances and the reasons behind the reneging decision. The ultimate burden is on you, as it always is in abusive process cases, to prove an abuse. The court didn't find an abuse here. The critical features were that there was a full-scale inquiry conducted before the instruction was given to renege, and there was no suggestion of bad faith. So what I suggest you take from it is an awareness that sometimes if deals seem too good to be true, somebody upstairs thinks that they are. And there may be circumstances in which the deal will be vitiated by a higher prosecutorial authority. But be comforted at least by the fact that those circumstances in which there can be a reneging, according to the Supreme Court of Canada, are supposed to be extremely rare, and they are subject to control through the operation of the doctrine of abusive process. Sean?
All right, we'll turn now to the topic of searches of cell phones, another developing area, and the Manly decision, also a decision of the Ontario Court of Appeal. In Manly, the police arrested the accused for armed robbery and also for break and enter. He was carrying a cell phone. During the course of a frisk search, the police took the cell phone from him, opened it up, started pushing the various buttons. Why? They wanted to look at the saved data. In doing this, they found a photograph of the accused holding a sawed-off shotgun that was taken a day after the robbery.
Can happen anywhere.
I have to say I was a defense counsel, but it still continues to amaze me why accused persons pose for photographs, go on Facebook, send emails, do all of the things they do that the police love to inquire after these days. In any event,
hey, look, it keeps you and I in business. What are you worried about?
The police found the photograph on the cell phone. The officer was concerned that if the cell phone shut down, the photograph would be lost. So one of his colleagues downloaded the photograph to his own cell phone and then in turn to a computer, so it was preserved. And then the police went off and got a warrant to search the remaining contents of the phone. The Court of Appeal found that the police were entitled to do what they termed a cursory search of the cell phone to determine whether it had been stolen, given that the accused was being arrested for break and enter. And they found that there was a link between that offense and an interest in the ownership of this particular phone. So therefore, the Court of Appeal concluded there was no Section 8 breach. What is important, it seems to me, is that the court makes some comments in the course of the decision, indicating that it does in fact recognize that in this day and age, individuals have a privacy interest in the data that is stored in their cell phones. And in fact, the court explicitly says that police officers should not and do not have an open-ended power to search a cell phone without a warrant, to search all of the stored data in an individual's cell phone on arrest without a warrant. And the court goes on and says the prudent course for the police to follow in those circumstances is to go and get a warrant to search the contents of a cell phone. So you can see the Court of Appeal going down the path of analogizing the data stored on a cell phone to the data stored in a computer, which is what many commentators out there have been urging on judges. And it seems to me that the importance of this decision is not just that particular analysis, but also the fact that it does put the police on notice from this point forward, that if they simply take a cell phone that they seize from an accused on arrest and start going through it to find everything that's stored on it, they are very likely going to be found to be in breach of Section 8 of the Charter, and I think will probably be in some difficulty on a Section 24(2) analysis. So if you have cases that antedate the decision in Manley, look at this case carefully, because I think it will give you some fodder for argument about charter breaches. I also think that this decision, along with the ones I've already mentioned about searches of computers, may give us some indication of the direction the Court of Appeal is going to go on when it comes to future variations on searches of computers and searches of cell phones without warrant.
Well, it's also value in determining the way we approach 24(2).
We being...
Yes, I used to be able to decide cases on my own. I can't do that anymore. So if you want the complete answer, you ask Michelle. If you want a third of an answer, you ask me.
All right, so David's going to speak briefly on the topic of the constitutionality and the elements of Section 229C of the Criminal Code, which is one of the homicide provisions. And I suggested that he deal with these two cases, notwithstanding that he was on the panel on the Shan case and notwithstanding that he authored the Rocks decision, because I think even for junior counsel starting out who are not doing homicide cases at this point, the kind of analysis that went into these two decisions, talking about the constitutionality and the constitutional challenge to a criminal code provision may be of some assistance to you. So David?
These two cases, Shand and Rocks, involve a section of the criminal code that defines murder, a section that is not utilized with a great degree of frequency. 229C is often referred to as unlawful object murder. And it provides that where a person for an unlawful object does anything that the person knows is likely to cause death, and by doing that causes death, he or she commits murder even though they desired to carry out their object, to effect their object, without causing bodily harm or death to anyone. So we can summarize the elements of this offense, it seems to me, by saying there's a requirement that the prosecutor prove an unlawful object. There's a requirement that the prosecutor prove certain conduct, which in a moment I will describe as a dangerous act. And there is also a requirement that the prosecutor establish a certain degree of knowledge or foresight of consequences. Shand was a jury trial. It was a prosecution for second-degree murder arising out of a botched robbery. And from Shand, we learned that what remains of Section 229C, and what remains is not as it is written, because some of you may recall that a number of years ago, the Supreme Court of Canada, in a case by the name of Martineau, said that the words ought to know, which would create objective foresight of death, were unconstitutional. And we interpreted in Shand the decision of the Supreme Court of Canada in Martineau and some other authorities to stand for the proposition that the minimum fault element that had to be established in a murder case was subjective, actual foresight of the likelihood of death. And we parsed out the elements in this way. Unlawful object has to be something other than the object of causing the deceased's death or bodily harm that the accused knew was likely to cause death and was reckless whether death ensued or not. It had to be an indictable offense requiring mens rea, and it had to be distinct from the act that caused death. The conduct requirement, which I will describe as a dangerous act, must be a specific act or a series of acts closely related to one another. The dangerous act can be, most often is, but there's no legal requirement that it be an offense in and of itself, and it must be distinct from the unlawful object. But what is important in these cases from your point of view of defense counsel, because this is often the area where there's most room to maneuver, is the knowledge or foresight requirement. It has to be actual knowledge or actual foresight. Ought to know doesn't cut it. It has to be actual knowledge or foresight of death and the likelihood that death will occur. So there's an element of probability attached with it. But I think importantly as well, and this emerges particularly from Shand, is that we say, and the court had said back in the 70s when this section was a little more frequently used by prosecutors, that this section has to be used with restraint, because you can't force every unlawful killing into murder by some contorted view of the circumstances underlying a killing, to force it within 229C. Because many of these cases, and Rox is a perfect example. Rox is an arson case. A bunch of guys decide they're going to torch Woodbine Hardware. It's an unoccupied commercial building because they've cleaned out all of the inventory. The purpose of doing this was to defraud the insurance company. They're going to set the place on fire, submit a claim for the building and the contents. Of course, the contents weren't there, but be that as it may. And on that site, erect a condominium. So the Rox is the middleman. His job is to go and hire the torch. So he hires two guys, one of whom is a fire suppression expert. Unfortunately, setting fires and suppressing fires are not the same thing. So they're in there spreading the gasoline around in the basement, just like they do in the movies. And like in my hometown, where the last guy out of town shuts off the lights, the last guy out throws in the match. Unfortunately, the building blew up with the fire suppression expert and his cohort inside. The fire suppression expert dies in the fire, and everybody gets charged with murder. That was a judge-alone trial. We substituted in Rocks a conviction for manslaughter because the trial judge made mistakes in her characterization of what the fault element is. And the curious thing about that case is that all of the people involved, whether those who pleaded at an early stage, whether Rocks who went to trial, or whether Mr. Magno who went to trial most recently, everybody got convicted of manslaughter, not murder, which in Magno's case gives you an idea of how 12 people see this, not as a murder case, but as a manslaughter case. Sean?
All right, in the interest of time, Paul, I think we'll do one more short case and then that'll be it. So here's a case I think all of you should have in your little toolkits if you take something to court with you that's some sort of brief synopsis or reference point. It deals with the applicability of the WD instruction. It's the case of Regina and BD. In that case, the accused did not testify at his trial, but did call 3 witnesses in his defense. The trial judge did not give the jury a WD instruction because the accused had not testified. The Court of Appeal held that that was an error and said that WD is not confined to cases where the accused, him or herself, testifies. Obviously, it applies to those cases, but it's not limited to those cases. The court said it applies where there are credibility findings to be made as between conflicting evidence called by the defense and the Crown, or conflicting evidence within the Crown's case because there's something in the evidence in the Crown's case that in fact is favorable to the defense. And something that immediately comes to mind is a statement by the accused that the Crown puts in because it has some inculpatory aspects to it, or something from which inferences could be drawn that inculpate the accused. But on the other hand, from the defense perspective, it also has some exculpatory aspects. So the court has said now in any case where either the accused testifies or the accused doesn't testify but calls evidence on his or her behalf, or even where no defense evidence is called but there's something in the Crown's case that favors the defense and there are credibility issues that that evidence touches on, then the trial judge must give a WD instruction. This is an important case because the jurisprudence was very, very unclear before BD was decided as to whether a trial judge ever had to give a WD instruction unless the accused got into the witness box. So you might want to take a look at it.
And that has to be right. It doesn't make any logical sense otherwise. It seems to me to confine WD to cases in which the accused testifies is an unnecessarily narrow reading of WD. I don't know whether you want us to do one more or sure.
I found it, so one question I do.
All right, why don't you do you want to do evidence of post-offense conduct, or do you want to do the HIV, that one? All right, evidence of post-offense conduct.
Post-offense conduct, the prosecutor's current darling. Everything is post-offense conduct now. You may recall that in the beginning, to get biblical about this, we knew this as evidence of consciousness of guilt. This evidence of things said or done by an accused after the commission of a crime with which she or he is charged and on which he or she is being tried. And that evidence, if you go back to the early cases, and this all goes back to this decision of the Privy Council called Mawes Con and Reginam. For those of you who are Latin scholars, Reginam being the accusative. 1967 judgment. The evidence was admitted, and if you go back to the basic principles from Mawes Con or from Professor Wigmore's text, It was admitted to show that the accused, after the offense that is charged was committed, acted in a way which, based on human experience and logic, was consistent with the conduct of someone who appeared to be guilty and inconsistent with the conduct of one innocent of involvement in the crime. In other words, consciousness of guilt was used to describe the conduct, rather evidence of the conduct, because it reflected a certain reasoning process, an inference that was going to be drawn. So time passed and we got rid of the label consciousness of guilt and got a new label, post-offense conduct or after-the-fact conduct. And unfortunately, it seems that one of the downsides to this new label is that there's a whole bunch of evidence that's now often urged as falling within that descriptive, that quite frankly has no place there at all. And in the most recent judgment of the Supreme Court of Canada on the issue, and I suggest that if you're going to read this judgment, it will be a bit of a struggle because there are 3 separate judgments, and it's one of those where you almost need, you know, those things they used to keep track of, the people who go to the Blue Jays games, keep track of the scores and whether it was a double or a single or what the counts were. You almost need something like that to keep track of it. So what happens in the new White, because there's an earlier one, White's charged with second-degree murder, shooting in downtown Vancouver. During the prosecution's case, the identity of the shooter's a live issue. End of the case, defense counsel effectively concedes, although there's no formal admission, that White shot the deceased, thus committed manslaughter. In the end of the day, then the jury has to decide whether the unlawful killing is manslaughter or murder. So things are going along okay until we get to the Crown's address, which sometimes does cause problems. The prosecutor argued that lack of hesitation, an absence of shock, and a lack of any appearance of uncertainty indicated that this was an intentional killing, thereby murder, as the prosecutor contended, not manslaughter, as the accused said. The trial judge gave a very, very brief instruction, saying you can consider what White did afterwards, but be careful with it. May not tell you much more than that for any number of reasons. He'd be in some kind of trouble if he stayed at the scene and may not be of much assistance to you in assessing his state of mind. White gets convicted of second degree. Majority BC Court of Appeal affirms the conviction. The further appeal, the Supreme Court of Canada, is dismissed by a majority of, ultimately, of 6-3, but on some legal issues, all 9 agreed. On others, a majority of 5, which consisted of 3 who dissented in the result and 2 who concurred in the result, hence my reference to the baseball scorecard, formed the majority. So what do we learn? Well, we learn these things. First of all, evidence of post-offense conduct isn't some special category or special species of evidence. It's neither more nor is it less than circumstantial evidence. And to get circumstantial evidence before the trier of fact, what do you have to show? It's relevant, it's material, and it doesn't offend any admissibility rule. At least the majority, if not the court unanimously, says, look, the great bulk of this evidence is just going to be admitted is that the court does say that there is no bright line rule that requires a special warning every time evidence of post-offense conduct is admitted. And the general rule is it's for the jury to decide on the basis of the evidence taken as a whole whether the conduct after the offense related to the commission of the offense charged rather than to something else. And if it did relate to the offense charged, then it's for the jury to say how much weight, if any, that evidence should be assigned in their final determination of guilt or innocence. Of course, you know that when they say there's no special rule, there's always going to be an exception. So the exception is that where judicial experience teaches that jurors may attach more weight to the evidence than it warrants, the judge is to alert the jurors to this danger in their final instructions. You might ask yourself, how do judges know that? Little further help is offered about the circumstances that engage this obligation. I think it's fair to say, consistent with their general jurisprudence about jury instructions, that no particular formula is required. But you might want to take something from the example they use, and the example they use is evidence of flight. And what was evidence of flight? It was the poster child for evidence of consciousness of guilt. So the next chapter, hopefully not in another white case. I refer to this one as a paler shade of white. With, and most of you aren't old enough, due deference to Procol Harum, Gary Brooker, and the Edmonton Symphony Orchestra, who did the song Whiter Shade of Pale. The next chapter, no doubt, will involve an exploration of in what circumstances is one of these special warnings required.
I want to apologize for my delay. There were a couple of unlawful objects I had to take care of. But
And so we're on the Nelly.
we do have one...
You got your factum done?
Greg's not here.
Yes, that's right. We do have one question from the webcast group, and I guess this goes back to your opening remarks, Justice Watt, regarding appearing before, well, I guess maybe any appellate court, but mainly the Ontario Court of Appeal. What advice or tips would you have to counsel that is going to be appearing there for their first time, whether it's a bail pending or an appeal, apart from saying, go watch experienced senior counsel that are there all the time, because their concern is that they just are concerned that they'll get it wrong when they show up there?
Well, I think one of the things I'd suggest at the outset, and this advice will vary depending on Enzo, whether you were counsel at, whether the appeal counsel was counsel at trial or not. In many instances, as I'm sure most of you know, counsel who appear before us are not counsel at trial. So if you're in that position, you need a solid information from trial counsel about what the potential grounds of appeal are. Although some prefer to draft a notice of appeal that consists of boilerplate, and in some instances it's perhaps unavoidable because you're just doing something to preserve your client's right of appeal, that does have consequences. And it'll have consequences particularly in bail pending appeal. Because one of the things that we take into account in deciding whether we will release an appellant pending the determination of his or her appeal is whether you've got an arguable case. And if all we see is the conviction was against the evidence and the weight of the evidence, the conviction was contrary to law, the trial judge didn't apply a reasonable doubt correctly, It's a bit hard to say on the basis of that, that this is a case that's got some arguable merit to it. So one of the early things you have to do is to explore as best you can with trial counsel, get a copy of the reasons for judgment if it's a judge-alone trial, get a copy of the jury instructions, any rulings on the admissibility of evidence, so that you can formulate at least more particularized grounds of appeal. You can always supplement them later, but try not to start off, particularly if it's a case where you'll be seeking bail pending appeal, with a boilerplate notice of appeal. Secondly, take a look at some notices of appeal that have been filed. Talk to counsel about, experienced counsel about the formulation of grounds of appeal, because that's your first document. That's the first impression that you make with the court. And as the materials come in, the transcripts, don't hesitate to get rid of grounds of appeal that don't have any root in the proceedings below. By the same token, if something emerges from those proceedings below, when you get the opportunity to review it, do not hesitate to file a supplementary notice or supplementary notices of appeal. When it comes to preparing the further material, just to sort of skip a few steps along the way, the factum is a very important document for us. It is the document that attracts the attention of those who will hear this appeal. If it is disorganized, if it is replete with error, if it doesn't give us a balanced picture of what this case is about, human nature being what it is, that's unlikely to attract our interest at the outset. So it should be organized, make use of subheadings, write it in plain language. There's no need for legalese. Avoid the gratuitous sniping that we see in some facta, and I'm not limiting this to defense counsel. I've seen it in the prosecution factums as well. That doesn't either speak well to your professionalism, nor does it advance your client's cause particularly. We do read all of the material that's essential for us to get a grasp on the case. Do we read every transcript? Of course we don't. We don't have enough time to do that. We'll read all of the rulings that are put in issue, the charge, the reasons, the facta, and as much of the evidence as we feel is necessary in light of the grounds of appeal that are raised. So be focused on what you have to say in your written materials, and be equally focused in the submissions that you make during the course of oral argument. Above all, talk to people who do this on a regular basis. Our experience with them is that they'll be very helpful.
So I guess I have to redo my factum. It'll be a little later now.
Well, I think that was the one you promised on Halloween.
It'll be more of a trick than a treat. But Justice First, just along the same vein, and I mean, you've done many jury trials as a defense counsel, but you only had your performance to judge it against. But now that you're on the bench and you've seen a lot more performances from different counsel, any similar tips to those counsel that are going into their first jury trial?
Well, this is not a novel comment. You've probably all heard it from various people along the way. You have to have, for lack of a better word, a theory of your case. You have to have a position that you ultimately want to argue to the jury. And the time to develop that in your mind is not the night before you have to give your jury address. Before the jury trial starts, you should have developed that position or that theory, and everything you do, ideally, during the course of the trial is directed to building that position, building that theory, so that what you're doing when you stand up to address the jury is not giving the jurors a synopsis of all of the evidence that you think might possibly be helpful to your cause, but you're weaving the bits and pieces of the evidence that support your client's defense into your jury address. I have to say, not just on the topic of jury trials or jury addresses, that when I talk to my colleagues who come from a civil law background, a civil litigation background, who as judges are just starting to hear criminal cases, what I hear from them time and time and time again is how surprised they are at the level of advocacy within the criminal bar, both defense counsel and Crown counsel, and how much more skillful the advocacy is from criminal counsel, defense and Crown, than it is from most counsel in the civil litigation context. So, you know, I think that even if you're just starting out, you're probably going to court reasonably frequently. You have an opportunity to hone your advocacy skills, and so your address to the jury really is the time when you should, you know, all of those advocacy skills should be coming together. And if you've thought through the position that you're going to argue, the theory of your side of the case, well in advance of the trial starting, you've developed it as the evidence unfolds, then you're going to tie it all together for the jury in your address.
Bear in mind, as trial counsel, you're creating the record. As appellate counsel, you're interpreting the record.
Well, I'd like to express our thanks again for both of you to attend. This was quite nostalgic, especially for me. It feels like we're back at Osgood, and I'm glad to see it's as informative and entertaining as it was just 2 years ago. So that's quite nice.
We're going to pip the ride now.